Practice, Acero. I'm the Complaints and Investigations Division Chief. And I'll be talking to you about the procedure that we have in the National Privacy Commission when handling complaints, requests for advisory opinions, and other matters that need to be brought to our attention. So, first let's go to the legal basis. We have three legal bases for what we do in the complaint division. First is the Data Privacy Act. The law does say that we have that power to entertain complaints and initiate investigations on our own accord. That provision is echoed in the implementing rules and regulations, particularly Rule 3 in Section 9 and NPC Memorandum Circular number 16-04. We have not come out with that yet, but we expect that to be out, and by January we expect it to be enforced. So, first let's go to the law itself. The law itself does say that we have the power to receive complaints, institute investigations, facilitate or enable settlement of complaints through the use of ADR, so on and so forth. So with that, Commission decided to create its own rules and rules of procedure. But before we get there, also in the implementing rules, we find that power echoed in Rule 3, Section 9. So normally the Commission acts through the Privacy Commissioner, but when deciding these cases, the Commission does act as a collegial body. So it's the Commissioner and the Deputy Commissioners deciding on the case, right? Under Rule 3, Section 9, it goes on further to elaborate that we can institute investigations on our own accord. So Eric, you're still here. Yes, you can. You can summon witnesses and require the production of evidence by subpoena. We can facilitate the settlement of disputes, and we can prepare reports. The idea is that when we come up with decisions, we come up with a system whereby we're able to inform the public that, okay, these are the precedents that are available to you for your guidance based on established case law. So specifically under the draft provisions, so as of now there's still draft provisions because we're still fine-tuning them. The rules apply to all complaints filed before the National Privacy Commission or for such other grievances, requests for assistance, or advisory opinions, and other matters cognizable by the National Privacy Commission. So if in case at a later date we have expanded jurisdiction over another matter of inquiry, then we can do that without having to amend it. So as we said, these rules of procedure cover everything. Requests for advisory opinion, complaints, investigations, matters that may be brought to the attention of the National Privacy Commission. Let's talk about the form. Lawyers like to think of forms as something that you have to follow very strictly, but here at the National Privacy Commission, we'd like to give some leeway, not a lot, but some. So you can get it through email at complaints@Privacy.Gov.PH. The rules do provide for electronic filing. While they provide for electronic filing, they do not do away with the requirement that the complaint must be sworn to. That requirement is there, so as a hedge against perjury. You can do it by snail mail, in this case, through, right now, room V-02 at the DICT building. But as we go and move and grow, it can be filed at any office of the National Privacy Commission. To make that process faster, the rules do require that first, it's in the form of an affidavit. Second, you include the affidavits of any of the witnesses. And third, you include copies of any evidence you will use to substantiate your claims. It's important to remember that in administrative proceedings, such as ones before the National Privacy Commission, the standard of evidence is substantial evidence, which is more than a scintilla, but enough to justify the ruling. Let's go to the contents. First, let us know who you're complaining against. Second, be specific with the details of the complaint. A lot of times, parties will just throw in, especially complainants, they'll just throw in everything, including the kitchen sink. But really, what we want to know is how were your privacy rights violated. Third, when you do that, please do specify what portion of the Data Privacy Act you say was violated. That will help the process further. Always include correspondence with other parties. We do not want any situation where a party is communicating with us by themselves and there's a semblance of partiality in those proceedings. Fourth, and lastly, include statements of what was done or what was not done in any particular situation. A lot of times in data privacy complaints, you get instances where what happens is because of neglect and negligence. In those cases, because negligence is a passive act, you cannot say that there was something that the person did that led to that situation. Now, because we do want the parties to be able to settle disputes by themselves and reduce the litigiousness that can attend these things, we put in exhaustion of remedies. So the point of exhaustion of remedies is, you just have to give the controller a chance to rectify the situation before any further damage happens, if that's possible. So you need to show proof that you informed the controller in writing. You need to show proof that the controller did something, or in whatever case did nothing. And you have to file that complaint within 6 months from the security or privacy concern, or 30 days from the last time you talked to the controller, whichever is earlier. The idea of that is we want people to be vigilant about their rights. So if you sleep on your rights and you're not, you let a particular incident slide, then that's your problem. So part of the power of the Commission is to award damages for any injury caused by a security incident. And because we haven't come out with a schedule of filing fee, we go to the rules of court for to fill any gaps in the law. And according to the rules of court, these are the filing fees for any claims that may be made in terms of damages or tort. Next thing that we have is, when we get the complaint. Okay, so someone puts in a complaint, he files an affidavit, he includes evidence, then we go to evaluation triage. And we can dismiss the complaint outright on several grounds. First, the complainant did not give the processor the opportunity to address the complaint. It's not fair. Second, the complaint does not involve any violation of the Data Privacy Act. Third, the complaint was filed too late. Fourth, there's insufficient information to substantiate the allegation. If you give a complaint to us and it makes us go into a fishing expedition, that's not allowed by law, and we have to shut that down. Next, because we recognize that there's a big gap in power between a data subject and the personal data controller, personal information controller, we put in a discovery process. And discovery is a means by which you can compel the other party to produce documents. So after this discovery report, the other party asks you to produce these documents to substantiate his claim on what was or what was not done. You have to do it. So after the complaint gets filed and we deem it proper for due course, then we'll call for a discovery conference. At the discovery conference, you'll talk about more or less the logistics of how discovery will proceed. And when that's done, you'll come up with a discovery conference report where you agree that these are the things that you need to do. Or, on motion or on any instance, if we're the ones investigating, we can call for an order governing the discovery. And we cover the same grounds that we ask the discovery conference report. There's a complaint, there's a process of discovery, and now we give you a chance to answer. So 10 days after the end of the discovery conference report, the processor, controller, or person alleged to violate the provisions of the Data Privacy Act does have 10 days from the discovery conference report to answer, include affidavits, witnesses, and evidence. Now, if the investigation team decides that there's more that needs to be uncovered, we may conduct site visits we can ask either party to submit more information. And when we're done, we're going to issue an order decreeing the case submitted for resolution. Now, part of the power of the National Privacy Commission under the law is to issue temporary bans on processing. So, for a temporary ban on processing, it requires a summary hearing, a payment of a bond in an amount to be determined by the investigator. The reason why that bond varies is because the amount varies between data subject and personal information controller. If it's a small matter, then it's a small bond. If it's a larger matter, it's a larger bond. And we wanted to give the commission enough leeway to make that determination. And if at the end of the proceedings, the ban is deemed justified, then that ban is permanent. So after resolution, we'll make a report and give it to the commission for their approval. What does the report contain? It contains our recommendations on the ban on processing, the amounts of damages to be awarded, persons to be recommended for prosecution, if any, the fines to be imposed, if any. When it comes to the commission, we talked earlier about the commission having the power to make the final decision. The commission will make a ruling. Now, if the commission deems it necessary to hold further hearings or the parties to submit memoranda to further clarify the issues, they'll issue that order. And then when the commission comes out with the report, the commission will ensure the confidentiality of the data submitted. And decisions of the commission must be appealed directly to the Court of Appeal. Okay. I'm almost done. I just want to recap on the important things that I said because it's that time in the afternoon. First, parties may ask for a temporary ban on processing, which means, first, complaints may be filed by data subject persons injured by a violation of the Data Privacy Act or by the Commission on its own initiative. Second, the Commission has the power to award damages, and that's going to be under the rules of court, under the rules of civil law. Third, if the complaint is given due course, parties will be made subject to compulsory discovery process. Fourth, parties may ask for a temporary ban on processing, which may be made permanent. And finally, appeals can only be made by Rule 43 of the Rules of Court of the Court of Appeal. And that's it for me.